Hello friends, I welcome you all to this 36th video on law of evidence, in which today we are going to study section 92 of Indian Evidence Act. So as usual, let us have a brief overview of what all we are going to study. The main focus will be what are the various exceptions to the rule of exclusion of evidence of oral agreement. That is, we have seen that chapter 6 is basically about best evidence rule. That is the cardinal principle that the best evidence should be provided. And therefore, in section 91, we saw that in case of any contract, uh, grant, or disposition of property which has been documented, then to prove it, the document itself has to be proved. Now, section 92 is one step ahead to section 91, where what it says is that is section 92 is supplementary to section 91, that once any such contract, grant, or disposition of property has been proved by writing, that is, the condition under section 91 is satisfied. Now, then no oral evidence, that is, no oral evidence can be given of these things to contradict or change the terms of contract. So, if these are the terms of contract, now that has been proved through written document, then in order to prove that there is any change, any modification, any contradiction in it, oral evidence cannot be given. What can be given is documentary evidence itself. So this is what is section 92. We will just read it. When terms of any such contract, grant, or disposition of property, or any matter required by law to be reduced to the form of document, as we had earlier seen in case of section 91, that it applies to both documents which are compulsory by law to be put in writing and documents which are voluntarily put in writing. For both 91 will apply and for both 92 will also apply. Have been proved, that is, once this document has been proved according to the last section, that is according to section 91, that is by documentary proof, no evidence of any oral agreement or settlement or statement shall be admitted as between the parties to any such instrument or their representative in interest for the purpose of contradicting, varying, adding to, or subtracting from its term. So, once this document has been proved, then anything, no oral agreement can be given to contradict its term. But as you see that only suppose this agreement has been taken place between party A and party B, then this section restricts only A and B or their representative in interest, not a stranger C. Stranger C can give oral agreement, but not A and B who are parties to the contract or who are the representative in interest. Now, there are various provisos, 6 provisos attached to it. But before that, let us see uh, two things. That first, what we saw is that the strangers, only the parties are bound, stranger to contract. Strangers can give oral, uh, oral evidence. That is one thing. Another is that it is a, we will compare section 92 with section 91. In case of section 92, only the Parties are bound and they are representative in interest. Strangers can give, but Section 91 is universal. That is, neither the stranger, no one can give the is universal. That is, even strangers cannot give evidence in case of Section 91, but in Section 92, strangers can give. Then Section 91 applies to both unilateral as well as bilateral. Both agreement or disposition of property, while 92 only applies to bilateral documents. That is, there has to be two parties here. So uh, remember, as far as section from this one you can remember unilateral, from this two you can remember bilateral. So remember that under section 92 it binds only the two, strangers are free. Under section 91 it is universal, it applies to unilateral as well as bilateral agreements. Now the rationale behind it, the idea behind this concept or this section 92 is that if we allow as the oral agreements to contradict the terms of the document, then the whole purpose of section 91 will be defeated. So this was stated, there is a case law, Raj Kumar Rajender Singh versus State of HP. It is 1990 Supreme Court. In this case, it was held that the rationale behind it, section 92, the idea behind section 92 is that the parties who have made a complete memorial of their agreement, it must be presumed that they have put into writing all that they considered necessary to give full expression to their meaning and intention. So, the rationale is that by writing, they have complete, or the writing should be considered to be complete in itself. Okay, and if the door to oral testimony is yet open, then it will open door to mischief and door to fraud, because then anyone will come and say that this I prove this document. Suppose A proves the document, B will say no, after this document is not valid because thereafter further oral agreement was made. So it will lead to a it will open up a door of mischief and fraud. So the section 92 is framed as such. Now we will just see certain examples in case where section 92 applies by illustration. So if it is that suppose there is an agreement between A and B, and agreement is that A will pay rupees 1000 to B. Now at the same time an oral agreement is made that A will not pay 1000, rather A will pay 1000, say 2000 rupees. So this is by written that A will pay 1000, and this is by oral agreement that A will pay not 1000, rather 2000. Then, as this is written, this will prevail. If this is proved, then this oral agreement which contradicts the written one will not be allowed to be given. Now, let us see certain what are the various exceptions to it, because these exceptions are very important. So first, in order to remember this exception, I will just give you one acronym as we have already been saying it. So the acronym is that, as you can see, this is a cell, and in this cell the prime minister is there. So former prime minister Indira Gandhi in 1978, she was jailed in a contempt proceeding of the parliament. So we will just remember it like, uh, so this cell is actually very small. How much? See its length and its breadth. So very small PM cell, and this child is looking at it with awe, surprised look it is giving. This, oh, that, oh my god, the prime minister is in such a small cell. So this is what is the formula to the various exceptions. This is the exception to section 92, this is exception to section 91, and as these three are exceptions to 91, so automatically it will apply to 92 also. So V stands for validity. So this is number one. So where the validity of document can be questioned, oral agreement can be given in that case. Now, how validity of an agreement can be questioned? It can be questioned that the agreement was made on the ground of fraud, or on the ground of mistake, or by uh, say intimation. So that is what we will read, that any fact may be proved which would invalidate any document, or which would entitle any person to any decree or order relating thereto, such as fraud, intimation, illegality, want of due execution, want of capacity in any contracting party, or failure of consideration or mistake in fact or law. So, first is regarding validity of the uh, document. Now, here there is one case law, that is Ganga Bai versus Chhajju Bai. Chhajju Bai. It is 1982 Supreme Court. Now, in this case, it was that the owner of the house, this is owner of the house, what she did is that she executed a nominal sale deed. So it was not a full sale deed, rather it was only a nominal sale deed. And she also made some rent note. Now, later on, to say person B, later on, B claimed, based on this sale deed, she claimed that the house is her own and not belongs to A. But as it was nominal in character, so A was allowed to prove that the document were not intended to be acted upon, and this rent receipt or rent paid was actually interest on the loan she took. So she had just uh, house was not actually for sale, but it was just as a security for the money she had borrowed, and the rent she paid, rent note, was actually the interest money which she used to give on the money borrowed. So anything which validate or which invalidate the document can be, oral agreement can be given to prove it. Now let us see the second exception to it, which starts with S, very small. As I told you, this is very small cell in which the prime minister has been kept. S. S stands for silent. So if on any point the document is silent, so for that the oral agreement can be given. But mind you, one should remember that it should not be inconsistent with the document. It should be consistent with the agreement as such. And another, so one is consistency has to be checked, and another is formality of the document. If the document is highly formal, then certainly in order to apply it, should be very cautious. But if document is not so, say, formal, then it can be easily applied. Now, there is one important illustration attached to it which will make it more clear. That suppose A sells horse to B, and A says that the horse is sound mentally as well as physically, and on the agreement it is just written that the horse was bought for rupees 500, and it is not mentioned that when it was asked whether horse is sound or not, what was said. Now, to prove that that A had asked for the soundness of horse and there some positive reply was given, oral agreement or oral testimony can be given as such. So, matters on which document is silent, on those matters the oral agreement or oral testimony can be given by the party, but it depends upon the formal nature of the uh, degree of the agreement made. Now, third is P, where P stands for precedent condition. So, if with respect to the agreement some condition precedent has been made, then as regarding that oral agreement can be given. For example, uh, there is a case Narayan Das versus Papa Mal. This is 1967 Supreme Court. Now, in this case, what happened is that A and B, their money was, simply saying, money was borrowed by B from A, and it was said that for 5 years, so for agreement was made, and it was said that say 5,000 rupee has been transferred from A to B, and orally it was agreed that for 5 years A would not demand any money from B. Now, this is a condition precedent as such. So, this to prove this aspect, oral agreement can be given as such. Next is M. M stands for modifications or rescission. Rescission means that when it is cancelled. So, if a document is cancelled or it is resist or some modification has been made by some oral agreement, then also one can give that to prove it. Oral uh, testimony can be given. Then this C stands for customs or usage. So, where the agreement is such that it allows that in the normal day-to-day function the custom or usage of the trade will be followed. In that case, oral agreement as far as custom and usage can also be given. Mostly this happens in case of commercial transaction. Then sixth is, these all are small, so please don't take it, only L you take it. So this means language. So if a language, in order to clarify that what does a particular word in that context means, for that oral agreement can be given. But mind you, there can be two conditions where the word's meaning is quite plain in itself. In that case, no evidence as such can be given. But where there is any doubt that this word may mean this also and the other thing also, that time only one can give the evidence. For example, if suppose a person makes a will that his property will go to his children, but he doesn't specify that who are his children. In that case, who are his children? So in that case, in order to clarify it, the evidence or oral evidence can be given. Now these six are those which are specifically mentioned under section 92. Three of them are also mentioned under section 91, as we have already said, and as they are mentioned in section 91, they will automatically apply to section 92 also. So as you can see, this child is looking in surprise that, oh, the prime minister is having such a small cell. So or is what we have made. So very small prime minister cell or the child. So or A stands for appointment of public officer. As we have seen that in case where a public officer is appointed in written, then it's not necessary for him to carry it all the time. If it is sufficient to prove that he has been acting as such. Then W stands for will. So wills for which probate has been made, that is, which has been certified by the court, will need not be carried all the time or will need not be proved. And E stands for extraneous fact. That is, facts other than those which are mentioned in the document can be proved by oral agreement. We have seen this in detail in our last class also. So that's all with section 92. We'll just remember, revise everything. That's what section 92 says. Section 92 simply says that if contract grant or disposition of property has been proved in writing, then no evidence can be given of any oral agreement to contradict or change the terms of contract. That is, no oral evidence can be given to qualify the terms of the document. But as we have already seen that there are two things. One is that it applies only to the parties as far as and their representative interest as far as section 91 92 is concerned, but 91 is universal in character. It applies to strangers also. Section 91 applies to unilateral as well as bilateral contract. Section 92 applies only to bilateral contract. Remember this because many times this has been asked in the examination. Then there are six exceptions to it. One is that in very small prime minister cell, or validity of to prove the validity of document, one can give oral agreement. On the point on which the document is silent, oral evidence can be given. If there is a condition precedent, then also oral agreement can be given. Or if there is certain modification or rescission of contract subsequent to after the documentation, that also can be given. Then for custom and usage, oral agreement can again be presented. And in order to clarify language where the meaning is not plain, oral agreement can be given. And in addition, the three exceptions to section 91, that is appointment of public officer, for will for which probate has been made, and to prove extraneous fact, oral agreements can be given. That's all for section 92. Thank you, friends.